What does Apple Store look like in Quartz eyes? Imagine it's a large restaurant. It has many chefs, servers, customers, and ingredients. In this restaurant, the chefs cook food and then servers deliver the plate of food to customers. There is also a kitchen management team that supplies ingredients and appliances to the chefs and impose quality control. Then imagine this. Chefs are the app's developers, plates of food are app services, and customers are users. The operating system, on the other hand, is the kitchen management. If you understand this analogy, you understand the case between Epic Games and Apple. Let's get back to the story of this restaurant. The food is great, the business goes well, and customers are very happy. The most popular dish is called Fortnite, and it's cooked by the chef named Epic Games. The dish then becomes so popular that customers are willing to give hundreds of dollars tips every night to the chef. However, the restaurant owner Apple would take 30% cut. Over time, the chef becomes angry and asks the owner why he would take such a large amount of chef's tips. The owner explains that the chef has relied upon the kitchen management to provide ingredients and kitchenware to cook the dish. The chef then said, "Well, that's because you forced me to use them. Your kitchen ingredients and appliances are nothing special, and I can cook an even better dish using my own." The chef then brought his own stuff and cooked the same dish. The owner then said to the chef, "You are fired today. You will never be my chef, and you will never cook your dish in my restaurant." There we go. One of the customer's favorite dishes is therefore removed from the restaurant's menu. This is a nutshell of the beef between Apple and Epic Games. It triggered one of the largest technology antitrust battles of modern era, spanning the United States, Europe, and now Australia. Today we are breaking down the legal war between Epic Games and Apple, what happened in US, what happened in Australian courts, and what it means for your firm, your apps, and your money. Epic Games is the creator of Fortnite, one of the world's most profitable games. At its peak in 2023, there were approximately 1.4 million monthly active users. Apple, on the other hand, requires all iOS apps to use Apple in-app payment system, pay Apple up to 30% commission, and not link users to alternative payment methods. For a smartphone, tablet, or personal computer to operate, it requires an operating system. The two largest operating systems for mobile devices are Apple's iOS and Google's Android. There are now more than 1.8 million native apps available on the Apple Store. Only a small number of these were developed by Apple. The vast majority are developed by third-party developers. Those third-party gaming developers can monetize apps in three principal ways. First, they can monetize their apps by charging users a fee to download the app. Second, they can monetize their apps through an advertisement showing the app. Third, they can monetize their apps by supplying users with apps in which users can make in-app purchases for which the developers can charge. Loot boxes, FC points, and V-Bucks are examples. Now, to offer in-app purchases, app developers require in-app payment solutions, which are systems built to have funds transferred without the user leaving the app. Developers like Epic Games can develop their own in-app payment solution or obtain the payment solution from a third party such as Stripe, Square, and PayPal. This is what Fortnite attempted to do, but was forbidden by Apple. In 2018, Epic Games implemented the strategy to develop its own store for PC games. By January 2024, Epic Games Store had about 75 million monthly active users. Its goal was to avoid paying commission to any distributors. This would result in breaching Apple's terms and conditions. Why? Apple Store is an exclusive platform by which iOS native apps are distributed. By reason of Apple's policies and technical restrictions encoded in iOS, only native apps from the Apple Store may be installed. This is different from Android, so you can see more than one app store on Android, but you can only see Apple Store in iPhone. So iPhone users can only download the apps specifically designed for iOS and published on Apple Store. Further, developers like Epic Games are contractually required to use Apple's in-app payment solution. Apple then charges a commission on paid apps downloaded from the Apple Store and any in-app purchases of digital content. These terms are non-negotiable if the developer wants to have their apps listed in Apple Store. Apparently, Epic Games do not want to pay that much commission. On 30 June 2020, Mr. Tim Sweeney sent to Mr. Philip Schiller, and other executives to Apple a request for a special side deal, allowing Epic to include competing payment processing options in Fortnite and other Epic software. This was soon rejected by Apple, not surprisingly. On 3rd August 2020, Epic Games submitted a new version of Fortnite version 13.40 to Apple. This version contained code that would allow Epic to bypass Apple's payment system once the hotfix was activated. But that secret code was not disclosed to Apple, and Apple did not pick it up. The new version was approved and updated in the app. On 13th August 2020, Epic Games activated the hotfix and made its payment system available within Fortnite on iPhone. Epic also deliberately offered players a 20% discount if they paid Epic directly. Apple responded within hours. On 13 August 2020, Fortnite was removed from the Apple Store. On 28 August 2020, Epic Games' developer account was terminated. Epic sued immediately. This was not an accident. Epic had a lawsuit pre-drafted, a PR campaign ready, and a now famous video making fun of Apple's 1984 ad. This was war by design. So how did the biggest antitrust case in Silicon Valley history actually end? Epic argued in the US court that Apple operated an illegal monopoly, forced developers into a closed ecosystem, extracted unreasonable commissions, and prevented price competition. Apple responded that iPhones are not a market. Users choose Apple voluntarily, and its security and privacy concerns justify restrictions. The case lasts for years from 2021 to 2024. At the end, Epic lost the monopoly claim. Apple won on most antitrust points, but the court ruled that Apple could not stop developers from telling users about alternative payment options. Both sides were not pleasant with the outcome. When it comes to Australia, the story is very different. Australia didn't just copy the US playbook, it opened a different legal front entirely. Epic launched proceedings in Australia under the Competition and Consumer Act, relying upon Australian consumer law principles, and in particular, Section 46 regarding misuse of market power provisions. Unlike the US, Australia has broader market power laws, less tolerance for take it or leave it dominance. Australia also sits within a global reform movement alongside the EU Digital Markets Act and UK digital competition reforms. The case has been heard before Justice Jonathan Beach. Importantly, the antitrust law in US and Australia are different. In US, it is accepted that monopolists' conduct can be offset or outweighed by pro-competitive justifications for that conduct, and the monopolist's liability thereby avoided. But in Australia, that does not work. When Apple attempted to ask the judge to adopt some similar findings in US case, the judge said this: foreign cases and their conclusions are a function of their different foundations. It is simply unproductive to linger on any analysis of them. The central issue before the Australian Federal Court was not whether Apple built a successful ecosystem, but whether it used that success in a way the law does not allow. Under Section 46 of the Competition and Consumer Act, companies like Apple having substantial degree of power in a market must not engage in conduct to substantially lessen competition in that market. We are talking about two relevant markets here. The first market is the iOS app distribution market, in which Apple provides to users in making a large range of apps available for download. The second market is the iOS in-app payment solutions market, in which Apple provides services to developers including processing and remitting payments for digital content within apps. Epic Games says, among other things, that Apple has breached the law because it has substantial market power in both markets and has imposed the restrictive contractual conditions with the purpose of lessening competition. Epic Games' arguments are supported by observations made by Professor Julian Wright's report. Firstly, even when Apple increased commissions, developers are unlikely to delist their apps because that would deprive them of the ability to reach the large and valuable base of users, who do not melt a home to significant extent and are likely to switch to another mobile device for the sake of accessing a single app. Secondly, there are only three ways for developers to monetize their products. Firstly, paid downloads, which require payment through Apple. Secondly, in-app purchases, which again required payment of commission to Apple. And thirdly, in-app advertising, which can bypass Apple's payment system, but the problem is who would like to see those ads when playing a game. Therefore, in-app advertising is unlikely to be attractive due to its effect on the user experience. Thirdly, Apple has set up rules that effectively prevent developers from diverting users to acquiring digital content on another channel. Fourthly, developer is neither likely to increase in-app purchase prices on iOS to divert users to alternative channels, nor likely to decrease the quality of their iOS apps in response to an increase in commissions. Lastly, even if developers pass on increase in commissions to users, it's unlikely to affect Apple or make Apple less profitable. Epic also argues that Apple's standard terms are unconscionable. The whole purpose of Apple's system is to consolidate its monopoly position and foreclose competition. Apple's arguments were that it did not have market power as purported by Epic Games because of a few sectors. Number one, Apple Store's commission rates have not increased since their introduction, and it's not that high compared to other distributors, such as Steam. Number two, if Apple had that much market power, it would not have heavily spent money on innovation to improve its services. Apple spent $101 billion on research and development between 2004 and 2020. To Apple's view, it was pushed to spend money to compete. Number three, Apple imposes minimum restrictions on developers' ability to monetize apps and does not have any pricing requirements within and outside of the Apple Store. Number four, Apple says that it faces substantial competitive constraints from numerous substitutes. These competitors include Google Play Store, Samsung Galaxy Store, Windows Phone Store, Amazon App Store, Nintendo eShop, and Apple Game Store. Number five, cloud streaming platforms have emerged as competing platforms, with developers and app users engaging in the same transactions as they do on the Apple Store. Apple argued that Epic could simply seek potential substitutions by providing discounts to V-Bucks on other channels. It is a matter for Epic Games to choose the transaction platforms on which their games are offered. It is also a matter for Epic Games to decide how app users will pay for games. But Epic Games choose to maintain uniform pricing for V-Bucks on different platforms, and that's why Apple users do not have incentive to switch to other platforms. Most importantly, Apple argued that its restrictions were legitimate product design choices justified by security, privacy, and quality control. When the original iPhone was first launched, it initially did not permit third parties to develop native apps. So the security features of iPhone were a high priority for Apple and Apple Store, and this continued to be the case. The court accepted that Apple holds substantial market power in two distinct markets: the iOS app distribution market and the market for in-app payment processing for digital content on iOS. The court had no difficulty to making this finding because Apple was the only supplier and had 100% market share. The court found that Apple could impose commissions without losing customers. There are two concepts relevant to such assessment. One is called device first, that is, user tends to rely on what is available on the device they choose and maximize enjoyment of their leisure time on this device. When Fortnite became unavailable on iPhones, users who previously played Fortnite on their iPhone while commuting by train or bus are likely to have switched to an alternative game such as Call of Duty and Creative Destructions during that time. The vast majority of iPhone users do not have access to Android device at all, so when an app is not available on iPhone, they will use other apps rather than switch the device. Besides, survey shows 10% or fewer of iPhone users who are acquiring another smartphone will purchase an Android smartphone. So asking players to switch a new operation system is almost impossible. Number two, clicks are costly concept. That is, to describe the phenomenon of users finding the requirement to execute additional steps to perform activities on electronic devices to be burdensome enough to deter the user from completing the activity at all. So if it takes too long to download another app or find another way to play in a different platform, they will not bother to do it. The analysis indicated that users execute 13.84% more transactions per month when using a biometric-enabled iPhone relative to a non-biometric-enabled one. The court accepted Professor Wright's conclusion that Apple Store has no close substitutes for app distribution services. This indicated market power. Justice Beach emphasized that the Australian Competition and Consumer Act does not prohibit market power. It prohibits using that power to substantially lessen competition. The question was therefore whether Apple's conduct went beyond protection of its ecosystem and crossed into exclusionary conduct. On the evidence, the court found that Apple's prohibition on alternative app distribution methods, including side loading, eliminated any realistic competitive constraint on the Apple Store. Apple's mandatory use of its in-app purchase system for digital content foreclosed the competition in payment processing, even where secure alternatives were readily available. Crucially, the court found that less restrictive alternatives exist that would have preserved security without eliminating competition. In addition, evidence in court revealed that Apple had a notorious reputation for enforcing restrictive terms with impunity, even against the largest developers. Examples include in 2016, Apple rejected the Spotify app. March 2018, Apple removed Tribe from Apple Store. In April 2018, Amazon Freetime Unlimited was forced to remove its HTML5 gaming functions before it got listed in Apple Store. In 2019 and 2020, Apple rejected NVIDIA GeForce Now app. The list goes on and on. Since 2017, Apple has terminated more than 2,000 developer accounts for failing to comply with its requirements. As to the security priority stressed by Apple, the court looked at some historic documents, including policy drafted by iOS security team back in 2007, but nowhere did it suggest that decentralized distribution is a security concern, or that centralized distribution is a security mechanism. Lack of documentary records and meeting minutes was largely due to Steve Jobs' management style in early age of Apple, which we can talk about in a separate video. It was not until 2019, when facing increasing levels of regulatory scrutiny and allegations about abusing control, did Apple's public relations team draft a new document titled Apple Store Story. Suddenly, this story changed the narratives and pictured that Apple's goal from day one was to create a safe and trusted place and give all developers an equal opportunity to succeed. But this is all too late. The key here is that the judge was convinced on face of evidence that iOS system and its payment solution were mainly developed for anti-competitive purpose. Apple's security-based justifications were either inadequate or cannot negate that substantial purpose. However, the court rejected several of Apple's broader claims. In particular, the court found that Apple's standard terms did not constitute unfair contract terms under the Australian consumer law. One point made by the judge is that it's necessary to consider the benefits Apple obtained through its relationship with Apple. The court was careful to distinguish competition law from fairness regulation. Strong commercial leverage without more is not unlawful. The purpose of competition law is to preserve competition, not to protect competitors, because competition is usually harmful to competitors. This case is not just about Epic and Apple. It's about how digital markets will operate in Australia going forward. For Australian users, if the judgment is upheld and implemented, iPhone users may gain access to alternative app distribution channels in the future. Digital content prices may fall as payment competition increases. Apple's control over post-purchase transactions may be reduced. The court recognized that consumer harm does not always appear as higher prices. Reduced choice and innovation are also harms the law protects against. For developers, the judgment significantly strengthens the position of Australian and international developers by reducing dependency on Apple's payment infrastructure, lowering effective barriers to entry, and increasing bargaining power against the dominant platforms. As a matter of fact, Apple has already adjusted its commission to 15% for small business program. Reduction of commission will be the trend. It is notable that since enactment of EU's Digital Markets Act and various regulatory interventions by EU Commission, Apple has made key changes to accommodate the new legislative scheme and reinstated the Epic Games developer account in 2024. For regulators and policymakers, the decision aligns Australia with a global shift toward tightened regulation of digital gatekeepers, alongside developments in EU and UK. It is likely to influence future enforcement priorities of ACCC and potential legislative reform. The federal court's answer was measured but clear. Ownership of a platform does not confer unlimited freedom to suppress competition. This case signals a turning point in Australian competition law, particularly in how it applies to digital ecosystems. The question now is not whether Apple will change, but how far Australian law is willing to go in reshaping the rules of the digital economy. Here are some questions for you to think about. Should a company that controls your firm control how you pay? Is Apple protecting users or protecting profits? And when innovation clashes with regulation, who should decide where the line is drawn? Thanks for watching. If you find this breakdown useful, like, subscribe, and share your view in the comments. We'll see you next time.